Greetings to you all. This is your brother Ambrose Weda Esq, lawyer and prolific published author. From the Greatness School, the Greatness Talk platform. Today we want to look at lawyering techno ethics. Lawyering techno ethics. Ethical issues that arise with the use of modern technology. I've been a lawyer for over 25 years, and I've served for over 7 years as an ethics judge in the Advocates Disciplinary Committee in the Republic of Kenya, elected by peers, professional colleagues. Over 25 years ago, when I was called to the bar, admitted as a lawyer, practice of law was manual, physical. Everything was about physical contact, manual contact, and things were done manually. Several years later, there has been development, monumental developments in technology that has changed the way we do things. And that has rendered it that the coming generation, the current and the coming generation in the legal profession, they need to know this, and they need to be careful, and they need to learn, because the fundamentals still remain the same. The fundamental ethical issues remain the same, but the circumstances change. So how do you fit? It is good to look at the history of lawyers and why I'm saying there has been fundamental shift. The legal profession started in the ancient Greece. Greece had what we call a semblance of the legal profession. People who are accused of crimes or people who are to defend themselves were obliged to do so, but they were also allowed to pick on a friend who could argue on their behalf. Now, these friends were not lawyers, but they were people who were specialized, people who knew what is called rhetoric, people who could argue things and do circumlocutions and turn upside down things, which has given the lawyers the uncanny name that lawyers can call white black and black white. So they were called the orators of the ancient Athens. These orators, it therefore meant that the relationship was personal contact, because it was you call a friend. And the contact was based on presence, physical interaction, and the procedures were manual. Whatever you wanted, you had to be there. But remember that you have a case. So the relationship entailed that you have to disclose very confidential information if the arguments were to be done in your favor. So it entailed the lawyer-advocate, the lawyer-client relationship is about handling sensitive issues. That brings in the question of trust. And the question of trust means that trust has to be guarded. It has to be surrounded and protected. If somebody is going to disclose to you very sensitive, dangerous information, then there must be an environment in which he or she has confidence and safety. This is the basis upon which ethics arose. Ethics are moral principles that define and govern good behavior. They are based on what is right, what is good, what is moral, what is proper. Ethics developed in the legal profession to set standards so that each person knows the standard expected of your behavior. But the work of the ethics was to insulate the lawyer-client relationship. Insulation was necessary so that you prevent betrayal, abuse, double dealing, suspicions, lies, and tricks, all gerrymandering required to be put aside if this relationship was to prosper. Ethics also set in place order, predictability, uniformity, standards, so that everybody is treated within a given standard properly and there's order. Ethics enable the advocate-client, the lawyer-client relationship to be elevated to a privileged status. That is the privileged status that facilitates you coming to me as a lawyer and telling me deep secrets of your heart, because there is privilege. In that privilege, the duties of the lawyer are defined strictly, and there are several duties. I'll look at 3 core duties and how technology impacts on it and how you should act. The 3 main specific duties of a lawyer is: number 1, you have a duty to the court. 2, you have a duty to the client. And 3, you have a duty to the law, to uphold justice, rule of law, obey court orders, all that. This video narrows this down to the duty to the client, the lawyer's duty to the client. And the lawyer's duty to the client is quite a number, but we'll look at 3. Number 1 is the duty of competence. Number 2 is the duty of confidentiality. 3, the duty to communicate. There's also loyalty and conflict of interest, to work in the best interest of the client, and several others. But we'll look at the 3: competence, confidentiality, and communication. So the first core duty of a lawyer to a client is the duty of professional competence. You are a lawyer, and a good one. What does the ethical regulation say? That a lawyer is obligated to provide competent representation to a client. And competent representation requires that you have valuable, proper, and current legal knowledge, skill, and diligence. You're required to keep abreast with the law, changes in the law, and the various practices that are applicable or that evolve. You will remember that lawyers sell knowledge. They sell information and skill. And one of the bases on which you assess and evaluate a lawyer is the level of knowledge they have. So professional competence is primary duty number 1. What is this? What comprises this duty of competence? Legal mastery, mastery of the practices, policies, procedures, customs, reasoning skills, research, professionalism, ethics and discipline, commercial competence, social intelligence, ability to use and apply technology, communication, advocacy, and continuing professional development, among other things that comprises professional competence. What is the scope of professional competence? You have to reflect deep knowledge in the area of law that you practice and in the general area of laws and the new developments. Knowledge, ability, application, training, skills, and then you are professional. In other words, you have discipline and you are diligent. You are required as a lawyer to have abilities to interpret, analyze, and apply the law and various practices in an efficient manner to provide quality, to provide value to the client. That also entails continuous study. In that scope is enveloped your ethical responsibility, which we will explain shortly. You're required to have knowledge, required to be efficient, required to continue developing, to assess when it comes to the use of technology, your ability to assess the benefits and the risks, and to apply both, to apply your knowledge to the advantage of the client. The second responsibility for the client, the duty that the lawyer owes, is called the duty of confidentiality. Remember, the advocate-client relationship, lawyer-client relationship, is a relationship of representation. Therefore, this duty of confidentiality, the ethical law is this, that a lawyer is bound not to reveal information relating to the representation of a client unless that client gives informed consent to the disclosure. There are exceptions to this. Quite a number of exceptions that I will, some of them include authority from client, obedience to the law, a court order, quite a number. But the basis is that you keep the core client communication confidential. Imagine in a society where a client would walk to your office, tell you about deep secrets of his own heart, then you go and yell about them outside. There will be no advocate-client relationship. What is the scope of this confidentiality? The duty of the advocate is to prevent unauthorized or inadvertent disclosure. Number two, to prevent access to that information that the client has given you. Number three is to control or prevent unauthorized access by third parties. Number four, there are people under your control, fellow lawyers, support staff, and other people, family. You're supposed to prevent or control access by people under your supervision. You have an obligation to secure the data in your presence, in your custody, in your possession. That includes securing them in water, fireproof cabinets, in a way that they cannot be destroyed or accessed. Number three is the duty to communicate. Remember, lawyers are representatives. We represent. So you act on instructions, and you're supposed to communicate information in such a way that your client makes informed decisions. You also have a duty to be efficient, to act efficiently, and to use processes that save the client money. What is the scope of the communication duty? Must be prompt consultations, informed client consent, reasonableness, use of efficient and cost-effective means, and keeping the client informed at all times. This has been the relationship, the way lawyers have practiced over the years. But then along the way, not less in this decade, there arose what is called technology, the rise of technology, which has a direct impact in this relationship. Technology is a body of knowledge devoted to creating tools, processes, and actions for purposes of producing goods and services. It can also refer to the products developed for the use or knowledge of techniques and processes being used. This is a word, technology is a word that came from Greek words, two words, techne and logia. Techne means the art or skills, and logia stands for a collection of skills, methods, and techniques and processes used in the production of goods and services or accomplishing tasks. Remember, lawyers began in the Greek times, but technology has changed the way we do our business, the way we do our work, the way we render services. This change has altered lawyering in a fundamental way. We now have what we call e-lawyering, electronic lawyering. And with it, the rise of ethical issues that requires you to know, to put your mind on, to address, and to be careful about. This is because the e-lawyering tools that we have today are quite a number, and you can't do without them. I'll mention a few of them. Now we have digital platforms, social media, Facebook, Twitter, YouTube, LinkedIn, blogs, all these things. We have cloud computing for storage, filing, backup. We have law practice management systems, word processing systems, e-discovery systems, video conferencing systems, voice over internet phone services, online fax, digital document transfers, emails, and so on and so forth. We now scan documents and we do electronic filing of documents. We are talking about paperless way of doing business. We have what is called collaborative word processing, ability to access your areas from all over the world. We now have voice-to-text dictation. You talk and it is translated into words. These e-lawyering tools have provided ethical challenges to the lawyers. There are ethical pitfalls that we need to look at quickly. Number one, we have what is called sensitive information. Like psychiatric information, hostile information, diminished capacity of our clients. Some information will require that you talk to the client directly. Some information you can't send through the internet. But you'll find that these tools that we have mentioned, they are all out of the lawyer's control. The internet is not in the control of lawyers. It also requires sophisticated body of knowledge. It requires a lot of costs to be expended to fit. Not to forget the cyber insecurities, attacks, and all these things. Now, these ethical pitfalls have challenged the practice of law and has put the lawyer at risk. And that risk, I need to explain so that you are careful. There are some areas that stand out. Number one is advertising. You and me, we are free to advertise our legal services over the internet. The internet is a public platform. So as you advertise, you end up reaching an unlikely audience. You can also end up with a problem called touting for legal work, which is unethical. Solicitation, which is unethical. Just because you are asking all over the world, you are asking all over the internet, you are asking in a way that maybe does not look ethical. Number two, you may end up with what is called constructive waiver of privilege. Again, being a public platform, the danger is exchanging confidential material, confidential information, let's say through electronic media, can amount to waiver, constructive waiver of advocate-client privilege. For instance, if a client writes to you an email, I want 1, 2, 3, I want you to tell me 3, 4, 5. It goes that you need to respond to that email in the same forum. But that may not be safe. The information required may be highly sensitive. But because it comes, it amounts to constructive waiver. However, constructive waiver has not been recognized by the ethical rules. So it cannot be a defense to you that by this conduct the client constructively waived. Because the duty to maintain confidentiality is on the advocate, and the decision to do it remains solely for the advocate unless it is expressly excluded by the client. Number 3, inadvertent retainer. Due to the public nature of the internet, a lawyer will find himself or herself discussing and meeting people in the internet and discussing legal things, offering a legal opinion, a legal position. And you may end up with what is called a lawyer-client relationship without planning for it, without meeting the necessary conditions. That is what is called inadvertent retainer. If you prefer a legal opinion as a professional, and somebody relies on it, somebody indeed in need, then that is the beginning of the relationship of lawyer-client. And that inadvertent retainer can easily lead to ethical pitfall. That is why you have seen the opinion expressed, blogs expressed in the internet, where the writers say that you are not supposed to rely on this. This is not a firm opinion. If you want a legal opinion, please retain the services of a lawyer. That inadvertent retainer has ethical pitfalls. Number 4, the ethical rule is that you are not supposed to contact or get in touch with a client of the other side, of the adverse party or the adverse lawyer. But you'll find in the internet, social media, Facebook, Twitter, a client on the other side can get in touch with you, sometimes without you knowing. By the time you discover, you find you have had contact, even discussed the content of the case at hand. Now that is also raising an ethical issue called a breach of no contact rule. You have unintended results, but as a lawyer, you are obligated never to get in touch and get into communication with the adverse party. So before you realize, you find yourself in that area of breaching the no contract rule. Next one, number 5, is cyber attacks. People are looking for information in the internet. The lawyer himself may not have knowledge, know-how to protect material that they have placed in the internet, the things that you have stored in the e-cloud and all other platforms. Information is being sought because what you are selling, what has value, is information. So there are cyber attacks, cyber criminals. However, when they attack, you may find that you have breached your duty of confidentiality and to keep the information safe, because that may end up damaging to your client. The next one, number 6, is basically ignorance. One of the biggest problems is ignorance. Limited know-how in the use of technology. Technology is not one of the core legal training syllabuses. It's not one of the core courses, a support course that may or may not be trained in, but it becomes a central vehicle through which you give out or you sell legal services. It has also become part of testing whether you are competent. So ignorance in e-lawyering, the tools that are used, the know-how, becomes a big problem to the modern lawyer, especially those who are trained in the earlier times. So that also raises a legal pitfall. The next one, number 7, is the fault of the client. Some clients play games. Some clients are really witch hunting the lawyers. I've sat in the Advocates Disciplinary Tribunal, and you find clients can be heartless and ruthless without compassion. In fact, many of the lawyers who have been hurt because they have also dealt with ruthless, heartless clients. There are clients who have been wrongly, truly offended by the act of errant lawyers. But there are also others who are looking for faults here and there, picking here and there. They want to recover the full fees they paid you. They want to recover everything. They want to bring you down, and they take pride in doing that. So any technological shortfall that brings in ethical issues puts the lawyer in danger. Next one is prohibitive costs. Electronic lawyering requires training, requires employing the services of people who are qualified, investment in the tools themselves, and large financial outlay to put the requisite structures. It puts off upstarting lawyers, young lawyers, people who are starting out. It makes starting law practice today more difficult. Prohibitive costs. Yet you do not get it right, you are doomed. Looking at it, therefore, the way forward, in order for you to be safe, in order for you to be careful, the first thing you do is to get into learning the depths of the e-lawyering system that has a mind, the use of technology. Get good, proper training. Number two, you can transfer risks. Take insurance with the consent of the client. Transfer the risks to those who are doing the work, e-cloud computing. Continuous learning, growing as technology grows, and then using highly protected internet systems, passwords and firewalls, and all the things that will be taken that you acted in a reasonable manner. Because the test is, did you take all the necessary steps that a reasonable person would have done in the circumstances? Either way, e-lawyering is here with us. We have to manage it. We have to do it. But we have to keep in mind the ethical pitfalls and to guard against situations where you find yourself cornered and punished. In conclusion, to quote John C. Maxwell, prolific author, publisher, teacher, pastor. He said this, and I quote, "Growth is the great separator between those who succeed and those who do not. When I see a person beginning to separate themselves from the pack, it is always almost due to personal growth." End of quote. I wish you all the best as you become better, as you learn the new tools, as you become technologically expert, as you become great, because we have developed the technological know-how and we will do it. Lawyers are a blessed lot, and we will continue succeeding and doing great. Thank you so much, and God bless you. You may subscribe to this channel so that you look at other things. We have looked at any things that grow lawyers. Subscribe by hitting the subscription button, that the newer materials that come, you can also read the old materials, because you know and I know that iron sharpens iron. Thank you so much, and God bless you.